Good afternoon. Happy Thursday. In Earl's case, the Court of Appeals has given the state of Texas an additional extension until April 8th. This is after the last time where they gave the state of Texas an additional extension and told the state of Texas no further extensions will be granted. I love it when someone sticks to their word. This time, though, the court, to show it's serious, they added another little caveat. They said no further extensions will be given, but they also said failure by the state of Texas to file a brief by the deadline may, not shall, not will, but may result in the Court of Appeals setting the matter at issue, meaning that no further briefs are going to be filed, and precluding the state of Texas from filing a brief in the matter. Does that mean anything? I don't know. I mean, I'm kind of learning with you guys. I don't think that the Court of Appeals would have given a non-state actor that many opportunities. So I think it's a bit of bullshit. You know, justice delayed is justice denied, as someone once told me, but everything in the law is delayed. I mean, nothing happens fast. So if the state of Texas does not file a reply brief or a respondent's opening brief, I think is what they call them. If they don't file one, they may not get oral arguments. I'd have to check the rules for criminal appellate procedure in Texas, and I'm not going to. I get a lot of comments like, "Are you an attorney? You always say I think or maybe or you qualify stuff. You don't seem like you do a lot of research on this stuff." Well, you know what? I'm not an attorney on this matter. I'm not representing Earl. I'm not representing the state of Texas. I'm not a Texas attorney. I don't get paid to do research on this matter. If any one of you fine fellows and ladies out there would like to pay me my standard hourly rate of $295 an hour to do research into this, I would be delighted to do research into this. But you don't, and so I won't. And also, I would caution you that my research would turn up what my research turned up, and maybe not what you wanted it to turn up. But anyway, if there are no briefs to argue, then there may be no oral arguments, and the Court of Appeals may just rule based on the record, which would be in front of them, which would include all the motions and arguments made at the motion for reconsideration, etc., by the state. So the state would still basically have some arguments in front of the court, just not directly through a brief. And the Court of Appeals would make their decision based on the record and on the brief that was supplied by Earl's attorney. I'm done guessing as to whether or not the state will even file a opening brief, or if they don't, if the Court of Appeals will grant them another extension, because the Court of Appeals left it open that they might. I mean, I'm done guessing. If it was anybody but the state of Texas, I would say you wouldn't have got that second extension, or you wouldn't have gotten an extension after the first one where it said no further extensions will be granted. If it was anybody but the state doing that. But, you know, I guess rules for thee and not for me, right? The rooster agrees. Everywhere I go, there's roosters, you know. I love cock. That's not going to get clipped out of context. So then Chilli. I get a lot of questions on will this conviction, the 19th, the conviction on the 19th, will that affect any of Chilli's lawsuits? And no, it won't. While the matter was somewhat at issue in Chilli's first lawsuit against LVMPD, he may have filed another one for his second one where he says he's going to sue the officers and the prosecutor. But in the initial one, in the one I've covered to date, where Michael Mee is representing him now as his attorney of record, and where there is a pending motion to dismiss, but nothing has come of that to the best of my knowledge to this point. It doesn't want to affect anything on that, because the trial court in that case, in that civil case, already found that there was probable cause. So it wasn't a wrongful arrest. It wasn't. Basically, all the matters were settled in that, except for supervisor liability. I believe that was something that was available to Chilli to replead, and all of the state causes of action and Fourth Amendment causes of actions that are related to excessive force, and those none of those issues were addressed at the criminal trial. So had there been no showing, had there been no finding by the trial court in the federal case that there was probable cause, had the court not already made a ruling on that, the lower court's finding of guilt, I think, would weigh heavily towards the federal court finding that there was in fact probable cause. If you get convicted of a crime, I mean, convicted means that it got proven beyond a reasonable doubt. So, or I mean, allegedly, it means that it got proven beyond a reasonable doubt, and probable cause is way less of a burden of proof than reasonable doubt, beyond a reasonable doubt. So it might have had an effect then, but at this point it doesn't have an effect. Is Ohio going to extradite him on warrants? Probably not. Again, they're bench warrants, so they're not going to pay to send someone out there to collect him and fly them both back just for bench warrants. They're just not going to do it, you know. In my experience, they're not going to do it. They haven't done it yet. They could have done it at any time when Chilli was in custody prior to this. I mean, the last time he got arrested, they most likely ran him and found out that he had outstanding arrest warrants in a different state, and they most likely contacted Ohio to see if Ohio wanted him, and Ohio most likely said, not really, no. We're happy if he just stays gone. So I don't think that'll affect anything at all. And the next question I got was, why doesn't he post an appeal bond? And I'm assuming that this was a question by someone who is in a state where appeal bonds are a thing. It does not appear to be such a thing for Nevada, at least as far as it concerns municipal courts and justice courts. Chilli's first case that he just got found guilty of was in a justice court. The second case that he just got arraigned for is in a municipal court, and you're going to ask why. And it took me a hot minute to figure it out. A municipal court has jurisdiction over misdemeanors that occur within the municipality. A justice court has jurisdiction over gross misdemeanors that occur within a municipality that would otherwise have jurisdiction over it. If it was a normal misdemeanor, like if Chilli was arrested for a normal misdemeanor in the city limits of the city of Las Vegas, it would still go to a justice court if it was a gross misdemeanor. It would go to the municipal court if it was not a gross misdemeanor. But outside of the municipal limits of the city of Las Vegas, outside the municipal limits of a municipality, it goes to a normal misdemeanor, also goes to a justice court. So even though it's a normal misdemeanor, because that first arrest was outside of the actual boundaries of the city of Las Vegas. I know it says city of Las Vegas as the city it's in, but it's not. It's unincorporated territory that is called... Sacramento has the same thing. There's lots of areas of Sacramento. Like the city of Sacramento is a small little boop in the middle of the county of Sacramento, and like a lot of the unincorporated area in Sacramento County is called Sacramento. So you could live in Sacramento without living in the city of Sacramento, if that makes sense. Same thing with Las Vegas. You could live in Las Vegas without living in the city of Las Vegas. And for some reason, the city of Las Vegas, the Las Vegas Municipal Police Department, patrols those unincorporated areas. Or maybe he started following the gal while she was still in the incorporated area of the city of Las Vegas, and he ended up pulling her over in the unincorporated area outside of the city of Las Vegas. But that first stop where Chilli interfered was outside of the city limits. So there you go. That's why it's in a justice court and not a municipal court. So the appeal procedures are slightly different between the two of them, and they're also similar. They both appeals will go to the district court. The district court normally handles felonies, but it also takes appeals from the municipal court and the justice court. They both have provisions for bail pending the outcome of the appeal. They both have provisions for that. But they're different, they're worded different, and I assume, having read them and read the language without doing any research into case law to figure it out, but it appears that bail from a municipal court is more or less mandatory. More or less. It's like it's the wording of the statute is like, if the defendant desires, the defendant can post bail. You can post bail, and it would include the fines and fees and any potential fines and fees for failing to prosecute the appeal, right? So he posts a large bail, and boop, he gets to walk until the outcome of the appeal. With the justice court, it's different. With the justice court, you have to basically ask the justice court for bail pending appeal. And that might have happened. There was something on the 20th, it looks like, from the court records, that I don't know entirely what it was. It might have been a hearing, because it is in the Register of Actions. But you have to ask the justice court for the bond, and if the justice court says no, then you'd ask the district court for bail. If the justice court says no to the bail, then you can ask the district court for bail. And because of that kind of progression of like, well, if the justice court denies, then you could ask the district court. Since that appears in the language for appeals from the justice court and not from the municipal court, that makes me believe that the municipal court is more or less mandatory, and the justice court is up to the discretion of the justice court, and if not the justice court, then the district court. I don't think that with my understanding of the current procedural posture and so I looked, and that same judge, that Zimmerman, Ann Zimmerman, the same judge was a judge at his arraignment, was the judge at one or two motion hearings that he would have participated in. So so it appears that she has had prior contact with Chilli, which might explain her actions at the beginning of the trial, demanding that Chilli surrender his phone and demanding other people surrender their phones, because my best guess would be that unauthorized recordings made it out. Courts can control who gets to record in the courtroom. I know a lot of auditors don't like it, but that is the way it is. And so that would explain, I think, why that happened. So, but considering, number one, that Chilli is currently out on bond or bail, maybe OR, for the municipal court, where he's facing essentially the same charges, and considering Chilli's, when the court was discussing that Chilli was looking for conflict, he makes money off it. He wanted it. He wanted to get in the cop's face, and Chilli was excitedly thumbs upping and nodding his head. I don't think the court is going to be very likely to allow him to go back out on bail, because he's indicated very strongly with his subsequent reoffense and his behavior, with the marshal, calling the marshal a pig, and not in agreement that he wants to seek out these kinds of interactions. I just don't think the court's going to allow him to go out there and cause problems while he's currently appealing. I don't think that's going to happen. Do I think there is any ground for appeal? No. I can't see, I don't know what grounds the appeal is alleging, but I didn't see anything watching it. I didn't see anything that would, I don't want to talk to you right now. I don't see anything that would lead me to believe that there was anything really amiss in that trial. None of the DAs, none of the DAs objections that were sustained seemed to me to be unreasonable objections. None of I don't know that me actually objected to anything. I don't think Chilli's attorney objected to anything. But if he did, nothing's jumping out at me as an objection that he may have made that would have been wrongly overruled. So my best hunch is that Chilli is appealing based on First Amendment grounds, and I don't think he has anything there because the court addressed the First Amendment issue. There was no First Amendment issue. Chilli was not told to stop filming. He was told to not interfere with the traffic stop and to move back 21 feet. Or thereabouts. He was told to move back, and the officer was never allowed to give a specific distance or a specific place because Chilli was just controlling the officer's lips too much. So I don't foresee any real good grounds for appeal. And like I said, the evidence is just so damning that it wasn't about First Amendment issues. It was about the officer getting to control the crime scene, which isn't unreasonable. I mean, cops can take something that's reasonable, like, yeah, cops should be able to control the crime scene, and make it unreasonable. And I've seen instances of it where, they're allowing people to walk right past the crime scene, but the guy with the camera, they're not, because they don't like him or whatever. So, I mean, I've seen instances where cops have taken something that is reasonable, like you should be able to control the crime scene, and make it unreasonable because of the way they enforce it. Unequal enforcement issues. Yeah. And finally, just because I've had a couple of people comment on, me saying, I've said multiple times in the past, you can go back to old videos, I've said I share a lot of beliefs with James Freeman. And people accuse me of being a sovereign citizen based on that. And let me help you understand. James Freeman has political beliefs that I don't endorse wholeheartedly, but my political beliefs are along the same lines as his. I'm pretty close to his political beliefs. Now, where James Freeman, I think, goes wrong, and where a lot of sovereign citizens, I think, go wrong, is where they take their political beliefs and think that those are or should be the law. And politics is not law. And law is not politics. Or at least it shouldn't be. I mean, sometimes there's lawfare is the current wording where people of one particular political persuasion are prosecuted differently than people of a different political persuasion. Do with that as you will. But James and I share similar political beliefs. I think the state exerts too much influence in our lives. I think it is a huge mistake of democracies and republics, which we are, is that we elect people to make laws. And so what do? They go and they make laws. Whether we need them or not, they go and make laws. Because that's their job. If you hire someone to do something, they're going to go do it. And they don't sit there and think, well, should we make a law? They're like, hey, let's make laws. What kind of laws can we make? That's a problem. I think it's a problem. That's my political belief. And what that does is it makes more and more onerous society's burden on the individual. We can no longer do things, we can no longer work things out for ourselves or do things for ourselves. We have to have governmental influence in every aspect of our life. Every aspect of our life. The clothes you're wearing have had to go through inspections because they're made in other countries, right? So they get shipped in, they have to be inspected. Why? Why should they have to be inspected? I mean, there might be a good reason for it, and I'm sure I'll get all sorts of comments about why, but I'm just saying, like, everything in your life, the car you drive, inspected. The tires you buy have had to go through some sort of safety inspections by the government. Not just by a corporation, but by the government. Like the glass on my windshield has been stamped certified by a government agency. It's insanity. And that's just part of it. I mean, like, everything you do, there's laws that govern it. I mean, just about everything you do, there's laws governing it. And I think it's intrusive, and I don't like it. But that doesn't mean that I confuse my political beliefs with the law. The law is what the law is. And I don't try to contort the law to meet my definition of what I want it to be. I don't take snippets of law out of context and try to turn them and twist them into saying what I want them to say instead of what they actually say. Because my job is based on being able to understand the law and being able to advise clients on what the law is and what their odds of success in any particular legal endeavor are. That's my job. That doesn't mean all attorneys approach it that way. There's a lot of attorneys who will take an hourly wage, an hourly rate, to argue what their client wants the law to be. And that's great. The client's happy because they're getting an attorney to argue what they want the law to be. And the attorney's happy because he's getting paid a lot of money. And it doesn't change anything. And, yay. But my particular philosophy is I want to understand the law. Whether it helps me or hurts me, I want to understand it so I could advise my client appropriately and help my client make decisions that are in the best interest of my client. And you may notice, if you've ever looked me up, I don't advertise. I never advertise. I don't even put you find very few videos where I actually state my full name or anything like that. I think maybe one or two videos have had my contact information in them. And I've had a few people approach me through YouTube for work. But my work all comes word of mouth from clients that I've had who said, you know what, this guy does a great job. He does a great job. He doesn't charge a lot. He's honest. I know it's weird to have an attorney be honest, but yeah. And I get good results. I manage expectations and I get good results. I get results within the bounds of the expectations that I set. So, I mean, to call me a sovereign citizen because I share political beliefs with someone is pretty ridiculous. But I guess that's what today's politicized society does, right? Because half the country thinks the other half of the country is extremist. Half the country thinks the other half of the country is extremist. And that applies to both halves of the country. Anyway, I'm going to get off my soapbox now. Thanks for watching. Have a great day.